My practice involves Title IX and college disciplinary matters. I've represented students on both sides as a complainant or a respondent, and students of all genders during a Title IX process at the college level and as well as the K through 12 level. I've also represented faculty in Title IX processes as well, although a lot of what I will be talking about will probably center more around students involved in Title IX matters and defamation claims. So Title IX matters generally involve sexual misconduct claims. And over the years, I've certainly, in my practice, I've been seeing a lot more issues of defamation intersecting with Title IX matters again and again. And certainly it seems to stem from situations where students will publicize their allegations about their sexual misconduct experience on campus, on social media, on the internet, within friend groups. And generally we see this happening as a way to gather support for their position. Sometimes students do this with or without a Title IX process. So meaning there's not always a Title IX process actually pending at the school when a student is publicizing the allegation. Sometimes there's no Title IX report made at all. And instead a student decides that they would, like to seek redress within the court of public opinion. We do usually see this practice happen more with students than with faculty. And we also usually see this happen more on behalf of complainants as opposed to those being accused of sexual misconduct. Naturally, if you're being accused, that you may or may not, be inclined to really publicize that more than it already is. So what happens when this type of publication occurs is that, and I think that some students don't realize this right away, is that they could be opening themselves up to defamation liability. But it completely depends on, the nature of what they're saying, the type of words they're using. And so, for example, if you see someone saying, I was sexually assaulted by so-and-so, I was raped by so-and-so, so-and-so is a rapist. Those are pretty specific words that have a criminal meaning behind them. You're accusing somebody of criminal behavior. And as Joe mentioned earlier, anything, when you are accusing someone of a crime that can lend itself to potential defamation per se liability. So that can be a situation where damages are already presumed because you're charging someone or accusing someone of a crime. Now, what do you do if you've been defamed or think you've been defamed as a student? You might think that your school can step in. And oftentimes students will alert the school, whether or not there's a Title IX matter pending, that, hey, there's, so-and-so is making a statement about me or has told, some people about, that I've done something that I did not do. And, can you stop this from continuing? And believe it or not, schools generally don't want to get involved with defamation matters. Now, they may step in if a situation rises to a level where it constitutes bullying or harassment. But in my practice, we've found that that's very rare. It has to be such an extreme level where someone's physical safety is being threatened. And even then, schools are just more likely to tell the student, you got to just seek legal counsel or preserve your rights with the courts or criminal justice system. So again, schools are reluctant to get involved because they don't want to prevent students from sharing their experience. And that's generally the explanation we receive from schools when a situation like this arises. And that goes both ways. Schools will allow both sides, respondents or complainants, to share their experience unencumbered. They don't like to put gag orders on students and prevent them from making statements, even if those statements could lend themselves to legal liability. They just don't want to get involved from a legal standpoint. So what that means is if you're a student who feels you've been defamed, your remedies are really not with the school. They're generally, it kind of forces the student to seek redress with the courts. And, you might be thinking, gosh, is this sort of a trend? Is this something that, we're going to be seeing a lot more of? I think certainly what students are finding is that accusations of this nature, if they believe it's untrue, can certainly be damaging, right? So beyond alienating you from your friends and peers, it can foreclose lots of opportunities both on campus and off campus. In our practice, we've seen situations where, former presidents of clubs and organizations have been asked to resign just with knowledge of an allegation, with no finding actually or outcome actually being rendered. We've seen fraternities and sororities also want to distance themselves from students who have had these accusations made against them publicly for fear of also, being associated with a potential rapist, and also job opportunities we've seen rescinded or foreclosed when someone is facing an allegation that's public, even if there's no court finding or school finding. So certainly, the stakes are high for students who, have been defamed, even in the Title IX context. And so they might seek, a lawyer that want, to help them seek redress with the courts because their school won't step in. So generally, when I'm hired in those types of situations, the first line of defense, would be a cease and desist letter. It would be something that we would serve directly on the student. It would identify the defamatory statements at issue. It would notify them that there are legal consequences to their actions. It would ask that the student stop immediately all future communications about these statements to others. And I've included a sample redacted cease and desist letter in the CLE materials, so you'll note that there. But, sometimes, believe it or not, students who are making public statements of this nature may or may not have a parent aware of what's going on. They may be acting on, his or her own. And so sometimes what we find, sending a cease and desist letter can help to get an adult in the room, like whether it's a parent or a lawyer, someone else to step in and also, kind of help to mediate the situation. Now, one practice tip is, especially if there is a Title IX matter pending between the complaining party and the responding party, you just want to be careful about school no contact orders, because generally whenever a Title IX matter is pending, there's an automatic no contact order put in place to protect both parties from contacting each other. So it prohibits direct contact between the parties, but it also prohibits indirect contact by a third party, such as a lawyer. So if you are in a situation where, you're thinking of hiring someone, or, you're going to be representing someone who needs to seek legal redress, you want to make sure that you're not violating the no contact order by sending a cease and desist letter. Schools will generally allow you to preserve your client's legal rights. So whether that's suing someone or threatening to sue them, but you should notify the school ahead of time to tell them your plans and let them know that you're going to need an exception to the no contact order in order to effectuate that. And so keeping an open communication with the school when there's a pending Title IX matter is very important, so that your client does not face a potential no contact order violation. Another strategy that we've found helpful in our practice, if we're representing someone who believes they've been defamed during the course of a Title IX situation, is that we may deploy a PR strategy and approach. So we would sometimes recommend to the client to hire like a public relations team to help respond to statements that were publicly made about your client on the internet or social media. PR teams can be helpful in strategizing the best response and strategizing where to respond, what platforms to use. They can also help with, moderating comments for you. But, the reason why this approach is sometimes used is because if a statement is made publicly about, you that's defamatory and it's on the internet, anything on the internet is forever, right? As we all know. So, certainly PR teams can be helpful because they're professionals that help, know the tricks and tips on how to suppress or push down bad internet results, which, is kind of the only way to combat something like that. So I think the only practice tip here is you want to consider each individual client's mental health and whether they can handle putting themselves out there, knowing that there might be potentially negative comments in response to their PR statements. So just keep that in mind when you're thinking of deploying a PR approach. So I've kind of gone over like sort of a general overview of the intersection of Title IX defamation in our practice, but I also wanted to go over a specific case example involving that intersection as well. We recently represented our client in a week-long trial in South Carolina involving defamation and civil conspiracy claims. And this was back in March of this year. And you'll see from the CLE materials that I included the proposed jury charges that we submitted in our trial, which were incorporated into the final jury charges. So a little on the facts of the case. The lawsuit arose out of a Title IX matter at Clemson University. Our client, the plaintiff, had consensual sex with the complainant, who was one of the defendants, at a fraternity party. The next morning, the complainant texted plaintiff asking him not to tell her boyfriend, who is also one of the co-defendants in the case. By the afternoon, her boyfriend had confronted her about the encounter after hearing rumors through the fraternity. Suddenly, the complainant stated that she did not remember having sex with plaintiff due to her alcohol consumption. The boyfriend stated, if you don't remember, then it's rape. Nevertheless, witness accounts from that night show the complainant was not actually incapacitated. Even though that was the case, the complainant continued to characterize the incident as a rape and repeated this to numerous friends and family in person and in writing. The incident was then reported to Clemson University, and Clemson found plaintiff responsible for sexual misconduct. It should be noted that Clemson University did not charge him with rape or sexual assault, which were also violations available under their policies. 1 year later, the boyfriend admitted to the plaintiff in a text message that he lied in the Clemson hearing and confirmed that the sexual encounter with complainant was consensual. Plaintiff then sued the defendants in South Carolina State Court for defamation and civil conspiracy. So what makes this case unique is that the defamation claim was not based on the statements that the defendants made during the Title IX process, but rather on the statements that the defendants made outside of the process. So as I mentioned in the brief factual overview, the defendants had all repeated these statements to numerous friends and family in person and in writing. So they made statements during the Clemson process, but they also made statements outside of the process before a decision by Clemson had ever been made. For example, the complainant engaged in public speaking events and told numerous friends and family about it. The boyfriend told several friends and fraternity brothers about it, and the complainant's father had told plaintiff's fraternity as well. So given that the statements made about plaintiff accused him of a crime of moral turpitude, the statements were defamation per se, and damages are presumed. Our civil conspiracy, just to note, was based on the defendant's collective actions and common plan to get him kicked out of the university. In the end, after a week-long trial, 8 witnesses, including 2 experts, a jury of 12 issued a verdict in favor of plaintiff on both causes of action for $5.3 million against the defendants. So as you can see that even though this case initially arose out of a Title IX matter, and even though there was a decision in favor of the complaining party in the Title IX sphere, it's still, because of the evidence and because of certain motions and the different standards in court, a jury of 12 still disagreed and believed that no rape actually occurred here and that the statements were in fact defamatory per se. And just quickly, if I have time, I want to just go over a last case to raise an unsettled issue of law. So in Conn v. Yale, in this case, I've included the briefs for this case in the CLE materials as well. This also arose out of a Title IX matter at Yale University. And the reason it's an important case is because the Second Circuit has certified a series of questions to the Supreme Court of Connecticut regarding whether a school hearing is a quasi-judicial proceeding entitled to absolute immunity. And this is an unsettled issue of law. And I think that it's going to be a really important case to watch. So let me just tell you briefly about the facts. Here, Conn was accused of rape by a female student at Yale. And while he was found not guilty criminally, Yale found him responsible and expelled him. He then sued Yale and his accuser in federal court for, among other things, defamation. And on February 9th, 2021, the case was dismissed by the district court because Jane Doe had absolute quasi-judicial immunity for the statements she made during the Title IX process. Conn then appealed to the Second Circuit, arguing that a private university discipline hearing is not quasi-judicial in nature and would not afford absolute immunity to proceeding participants. And so that's what led the Second Circuit to certify these questions to the Connecticut Supreme Court. So I want to just point out, the difference here in this case, unlike our South Carolina case, where the defamation claim was based on statements outside the Title IX process. the Yale case involved statements made during the Title IX process. So that was a major difference in strategy, as well as, you know, how the claims were based. And that lent itself, obviously, to this absolute immunity defense. So again, I think this is an important case to watch. Oral arguments have not been heard yet, but even though it only entails Connecticut law, I think the decision may have ripple effects in other states on whether a Title IX process is considered quasi-judicial and whether statements made during that process are protected by absolute immunity. I think it will also have an impact on future potential lawsuits by students against other students, and potentially may have, you know, depending on what the answer is, a deterrent effect on future filings. But we'll watch out for that. And with that, I wanted to turn things over to my colleague, Karen.